Okay, I think we have both counsel for this case with us, Attorney Troutman and Attorney Torrance. Is that correct?
That is
Remember,
correct.
you have yourselves down, not muted anymore. Thank you.
Yes, Your Honor.
Okay, let me start with counsel for the appellant. Attorney Troutman, did you wish to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes, please.
Okay. We have everyone still here on our Zoom, so we are ready to zoom on. Please go ahead, Attorney Troutman.
Thank you. Good morning, Your Honors. Shannon Troutman of Albertoli Law, off of the appellant, U.S. Bank National Association. Final judgment in favor of Ms. Azlahi and Mr. Barakat should be reversed, and this matter remanded with instruction to enter final judgment of foreclosure in favor of U.S. Bank. There is no dispute that Mrs. Azlahi executed a note and mortgage and then defaulted only 3 years later. There is also no dispute that U.S. Bank set a proper notice of default with opportunity to cure. The sole ground for final judgment in appellee's favor appeal is U.S. Bank standing to foreclose at the time the original complaint was filed. The record evidence and competent witness testimony at trial make it clear that U.S. Bank owned the note and mortgage not only at the time that the complaint was filed, but within a month after the loan was executed in 2006. This was 3 years before the complaint was filed. No other entities have held an interest in the loan since. The evidence and
let me
competent
jump in
witness.
for a minute. I think
Sure.
that the problem as I see it is that when the lawsuit was filed on December the 23rd, 2009, the foreclosure suit, there was also a lost note count filed at that time, correct?
Correct.
And so the bank was essentially saying, we own it, we are the holder, but we don't know where it is, it's lost, we can't come up with it. And in fact, they couldn't even come up with a copy of the note to attach to the complaint. There was some sort of a listing of the factual terms of the note, but there was no actual copy of the note, right?
That's correct to an extent. You have to keep in mind that in 2009, the pleading requirements that are in effect now weren't in effect. So the requirements for pleading were a lot more lax. So even though a lost note count was included in the complaint also included language that U.S. Bank was the owner and holder of the note, and that they were entitled to enforce it. And at that time,
I understand all that language was in the complaint. That's not where I'm going with this.
Okay.
In February of 2010, about 3 months later, there was a summary judgment motion filed by the bank along with a lost note affidavit, correct?
Yes.
And again, the bank
Your Honor.
at that point asserted by affidavit that they, despite having a diligent search and a thorough search, they could not come up with the note, correct?
Yes. However, I would like to point out with regard to the lost note affidavit, as you stated, Your Honor, it was filed after the complaint was filed.
Yes, it was.
Yes, and it was executed after the complaint was filed, and it related only to the time that the lost note affidavit was filed. It did not relate to the location of the note at the inception of the case, and Florida case law
But it's sort of
is
it's
very
dovetailed.
clear that a plaintiff only needs
The
to.
lost note affidavit basically reiterated what was in the lost note count at the time the complaint was filed 3 months earlier. In other words, we don't have the note, we've looked for it, we can't find it, it's gone, it's missing. And so that's what's alleged in the complaint, and then that's what's also asserted in the affidavit. And I think the issue with respect to standing is years down the road, the witness at trial said, no, wait a minute, in effect saying we were mistaken, we actually did have the note. The note actually was in our file, in our possession, and I can tell by looking through the computer records that that is in fact the case. So help me out. Judge Little goes on to find against you on the foreclosure. Basically, as I understand what he said on the record was that you've got you got a problem here, because how can you, on the one hand, be a holder of the original note whereas the complaint says you don't know where it is and you don't have a copy of it. The affidavit says the same thing, and now the witness is saying something diametrically opposed. So you have the record showing one thing and the witness showing something else, and I think that's where your problem lies. So help me out with that.
Sure, Your Honor. I would point out that the original complaint doesn't just include a last note count. It also pleads that plaintiff is the holder. So while
It says that, but
the pleadings
but in
aren't
the lost note
in
count, it
this
says
case a lot
it doesn't know
easier
where
if
the
they
note
were.
is. So don't you have to have possession to be a holder?
Yes, Your Honor.
I think there's a difference here between pleading and the evidence the court heard at trial. He hears a custodian testify somewhat about what the records show and are not able to show, plus admitted into evidence as an affidavit that says, we don't know where it is, we don't know where it's at, and we don't know when we got it. And the trial court has to weigh the evidence. And if the trial court says, I don't find that credible, how do we get around that if there's competent evidence to support the trial court's holding?
Your Honor, I understand your concern. I would like to point out that the last note affidavit was not admitted into evidence. The court just
Didn't the
took
trial court take
judicial
judicial notice of it?
He did take judicial notice of it. He also never stated that.
Doesn't that become evident? If a trial judge takes judicial notice, doesn't that become part of the evidentiary record?
Yes, it is part of the evidentiary record, Your Honor. I would like to note that the trial court judge never stated that the witness testimony wasn't reliable. He focused on the last note affidavit, which again, I would like to point out was not filed. It was not with relation to the times when plaintiff has to prove standing. And
But
if
the
you look at
affidavit
it in
was
the
filed by
context
a
of
party
the
to the
case as a
lawsuit
whole,
and contradicts other evidence that the party to the lawsuit is bringing in. My concern, it's almost like, and this is not a perfect analogy, forgive me, but in certain criminal cases, you have to show a chain of custody. And here your initial chain, if you will, says, we don't know where it is. And now somebody else is coming in and saying, well, I've looked at the computer and I think we could presume. Well, the trial judge does not have to presume that to be the case. And I think that's what the trial judge is trying to say. And I may be wrong. That's why I'm trying to say, how do I measure the evidence before the trial court and his last comments on page 770 and 771 of the record, where he says there's holes in the case and things of that. My concern is the trial court within its authority to find the evidence not sufficient to meet the burden of persuasion of a preponderance? If the trial court is, we don't get to reweigh it. If there is incompetent evidence, we can look at that. And I think that may be what Judge Black is also concerned about, but I don't want to speak.
I think you said it better than I did, but that's what I'm trying to get to. Judge Little said the witness says, look, I presume because of the fact that the note is here in the computer records, I can presume that it was endorsed. Well, maybe it was and maybe it wasn't, but what we do know is that back at the time the complaint was filed, followed shortly thereafter by the summary judgment motion with supportive affidavit, the bank had no idea where the note was. And now the witness says, no, it was there all along. And so the trial judge is wrestling with that.
Again, I would reiterate, the last note affidavit deals with where the note was during the case, not at inception or judgment. And when looked at in context with the MSJ that was filed, you could say that the last note affidavit should be looked at with regard to plaintiff standing at the time of judgment, should the MSJ have been entered, not the inception of the case. And therefore, it's not relevant to this, it doesn't weigh against the testimony and other evidence that US Bank entered during the trial. While the witness did say that he saw the note in the in the file, and that's how he presumes that it was signed before. He also testified as to U.S. Bank's standard operating procedures and policies with regard to onboarding loans. And in that, he said that U.S. Bank would not purchase a loan if it did not come to the bank and properly endorsed so that they would be able to enforce it. And the second DCA has case law that's right on point with that, with those fact patterns. In Cummings, the court held that business records combined with witness testimony that bank held a note prior to the complaint is sufficient to establish standing. In Elizen, this is a recent.
In the One West versus Cummings case, there was an actual note attached to the complaint, which we don't have here. The issue is
there was, but the endorsements on the note in Cummings weren't, did not convey standing on the plaintiff in that case. So, and again, at the time of the filing of the complaint, the only thing that was required were the substantial facts of the note. You weren't required to file a copy of the note. And I would say that in Cummings, it's indistinguishable from this case because either way, plaintiff had to prove
the court in Cummings notes One West attached to its complaint a copy of the mortgage and the adjustable rate note with a blank endorsement. We have neither of those in this case.
Yes, but then the note that was offered into evidence in Cummings at trial was different from the note, the endorsements on the note that were attached to the original complaint. So either way,
neither note was dated. That was the issue. It was just a dating issue. In our case, we have no note and no endorsement and no date either.
Understood. There's further case law. A recent May 1st, 2020 case that was submitted as a notice of supplemental authority, Elizen from the second DCA, stating that testimony from a competent witness may be used to prove that an entity had the right to enforce the note on the date of filing. And that case cites to Pugero out of the fourth DCA, in which the fourth DCA stated that testimony regarding the servicer's routine business practices to establish that an endorsement was effectuated prior to filing was sufficient to prove the plaintiff's standing. And those cases are right on point with the fact pattern here. We have witness testimony establishing that U.S. Bank would not purchase a loan if it was not properly endorsed so that they could enforce it. U.S. Bank later filed the note with blank endorsement in the case. There were a note acquisition screenshot that was entered into evidence showing that U.S. Bank acquired the loan in June of 2006, well before the complaint was filed. And that acquisition screenshot also noted that they held or possessed the original note. And the witness testified that once that acquisition screenshot information was entered, it couldn't be edited. So the boarding process was followed and showed that U.S. Bank was in possession of the original note. There's also the loan purchase setup sheet that was entered into evidence, which showed that the loan was acquired and purchased in June 2006. And finally, the payment history shows that U.S. Bank received payments for the loan from its inception, and no other entity has had any involvement with the loan since then. The payment history begins in August 2006, and that starts record page 6. So in a combination of these, this testimony and evidence admitted into at the trial shows that U.S. Bank was entitled to force the note when the complaint filed. And I think that the focus on the last note affidavit is misplaced because, again, I believe it goes to the location of the note at the time that U.S. Bank was hoping final judgment would be entered as a result of the motion for summary judgment. And that's not a time that U.S. Bank has to prove standing.
Okay, thank you.
Thank you, counsel. Okay. Do you wish to rely on your brief for that parts and then we'll move on? Because you still had a little bit of
If I'd
time
like
left.
I'd like to, I'll reserve for rebuttal, Your Honor.
Okay, thank you. Mr. Torrens, I guess the floor, so to speak, electronically is yours.
Thank you very much, Your Honors. Good morning, and may it please the court. My name is Ryan Torrens, and I represent the appellees in this appeal. Your Honors, following the non-jury trial in this foreclosure case, the trial court correctly entered judgment in favor of the appellees, as the appellant failed to meet its burden to prove standing at the inception of this case. Your Honors, this court has long held that a plaintiff in a foreclosure case who is not the original lender on the original note must prove standing at inception, and not only must prove possession of the original note, but also must prove that the endorsement on that original note was placed prior to the inception of the litigation. We submit that the appellant failed to do so in this case. Your Honors, in the case at bar, we have an original complaint that was filed with a lost note count. We then have almost 2 months into the litigation, a copy of a note being filed by the appellant with no endorsement on that note at all. That's 2 months into the litigation. Moving forward on the timeline, the appellant then goes and files a number of sworn affidavits under oath and penalty of perjury, stating that the appellant cannot locate the original note. In fact, in one of those affidavits, the appellant states that the original closing file was reviewed, the servicing file was reviewed, and a vault was reviewed, and they cannot find the original note. Some of these affidavits sworn by the appellant were filed years into this litigation. Your Honors, then moving forward, the endorsement that was brought up at trial, the endorsement in blank, does not make its first appearance in this case for almost 5 years into this litigation. The trial court, Judge Little, granted leave to file an amended complaint to the appellant, and the appellant took almost 5 months to finally file its amended complaint. When it did so is when we finally see 5 years into the case, the endorsement in blank.
That would be the amended complaint filed in November of 2014.
Yes, Your Honor, that is correct.
And there have been no payments on this note, according to the trial evidence, since 2009?
That is correct, Your Honor.
Let me ask you this question, and I'm concerned that the analysis may exceed our review scope, but I think the case was Bartram, the Supreme Court of Florida announced the rule that any subsequent defaults in payment would create a new cause of action. And if that is true, then after the amended complaint took place, there was continued breach. And there doesn't appear to be any dispute that they would have established their standing as of for the amended complaint. Would we have the authority to remand it back to the trial court to say, calculate damages from that breach?
No, Your Honor, I do not believe that.
My concern is it's not been raised, no one's had a chance to argue it, and there's a due process. But it kind of struck me as I was going through this file with the tipsy coachman rule, because it is in the record.
Correct, Your Honor. That is in the record. And for purposes of standing, I don't believe this court would have the authority to order that. I believe that here it would have been much more prudent for the appellant to simply voluntarily dismiss this case and bring a new filing when it had the original note with the endorsement. Under the Supreme Court's holding in Bartram, they are certainly allowed to do that. We've had cases where multiple new foreclosures have been filed.
Arguably, they had the ability at that time to make the election on how to proceed, and they chose this course.
That's absolutely correct, Your Honor. That is correct. And so moving forward, when the case finally gets to trial, the witness does not know where the original note was located at the inception of the case. I was trial counsel as well. I pressed the witness as to when the original note may have been scanned into the computer system. He did not know that. You can see by reviewing the transcript, Judge Little presses a few times of the witness. can you tell us when that original note would have been scanned into the system? He said, I can't give you a date. No records were brought to court, no copy of the scanned in version of the note to show when it may have been scanned in. And so the testimony was woefully insufficient. In the briefs and at trial, Your Honors, the appellant relies quite heavily on this acquisition screenshot. I believe that for the appellant, that acquisition screenshot cannot carry the day. That acquisition screenshot, if you look at it carefully, was printed and is dated for 2018, years and years into this litigation, and actually shortly before trial. There's an entry that indicates it may have been purchased in 2006, but there's no indication as to when US Bank would have come into possession. And even if it did show possession, which it does not, it does nothing to show when the endorsement was actually placed on that note, especially in a case where the first time anyone saw this endorsement was 5 years into the litigation. Your Honors brought up the affidavit in questioning counsel for the appellant. The trial court did in fact take judicial notice of that affidavit. I was then able to use that affidavit to essentially impeach the witness's prior testimony with respect to standing, and the witness didn't really have any good explanation for that. I think the affidavit is particularly problematic for the appellant in this case because the appellant has the burden to prove standing at inception. And so well into the litigation, you can see the appellant stating, we're looking, we're searching, we're reviewing the files. We cannot find this note, and even trying to get a summary judgment on a lost note claim, and then appearing at trial and trying to contend that they always did have the note. And that's why I submit, I think it would have certainly been more prudent for the appellant to take a quick voluntary dismissal and refile the complaint, which they would have been permitted to do so. Your Honors, also in our briefs, we mention a few cases that I would like to just bring up briefly. I believe that this case is quite similar to this court's holding in Corrigan. In Corrigan, you also had a lost note case that was filed. And I'm sorry, there was a note attached to the complaint in Corrigan, but there were no endorsements. And then the endorsement shows up way later in the case. And in Corrigan, this court said, look, that's not sufficient. It wasn't attached to the complaint. You don't have any additional evidence of standing. And in fact, actually in Corrigan, there was no note attached to the complaint, just like in our case. No note attached to the complaint. A note shows up later with an endorsement, and they just can't make the connection and prove that that was there at the time of filing. So we think the facts are very similar to Corrigan. And also other cases as well, such as Winchell. This court has held repeatedly that the bank has to prove that that endorsement was there at the time of inception. Counsel for the appellant tries to rely pretty heavily on Cummings in the briefs filed by the appellant. And there are some clear differences there too. And Your Honors have already brought up those differences, such as—
And we are fortunate the author's on the panel.
Yes, exactly. So, Judge Kelly knows this case very well. And there was an endorsement in blank attached to that complaint, which is not what we have here. There was not just an unendorsed note, there was actually no note attached to the complaint as in Corrigan. So we believe that Your Honors can affirm the judgment below and remain consistent with Judge Kelly's holding in Cummings. Also cases even going back to Russell, which I know is a Judge Black opinion, where Judge Black correctly held that the plaintiff does bear this burden to prove possession and endorsement at inception. And the appellant failed to do so here, Your Honor. I would also just like to very briefly address the argument advanced by counsel about routine practices. I also don't believe that uncorroborated testimony can carry the day for the appellant here. I believe in a sentence or two, the witness stated that the bank has a policy not to accept loans that don't have the right endorsement. But the bank representative also testified he didn't even start working for the bank until 2 years after this complaint was filed. There was also no written policies admitted as to what the actual policy was in 2006 of U.S. Bank, when the bank tried to take the position that they acquired this loan in 2006, and there wasn't even any testimony as to what the policy was in 2006. And so I don't believe that carries the day either. This is a pretty egregious standing case for the appellant here, Your Honors. And unless Your Honors have any additional questions, that would conclude my argument.
Thank you, counsel. I will note in your presentation, you were good enough to cite Judge Kelly and Judge Black. I hope I didn't offend you any time during the process.
Not at all. I always look for that before the oral argument. So thank you very much for your consideration, Your Honor.
Thank you, sir. We will rebuttal time. Counsel, you still have 5 minutes.
Thank you, Your Honor. Again, I'd just like to reiterate that what we're focused on here is standing at inception, and opposing counsel is focused on the last note affidavit for obvious reasons. On its face, it doesn't look good for plaintiff and standing. However, the last note affidavit, again, does not, it's a moment in time that's during the case. It has nothing to do with the inception of the case. As an analogy, I have my car keys, they're somewhere in my house, I can't find them. That happens a lot, and then I found them later. But I did hold them in the beginning, and that's when it mattered. It didn't matter where the note was when the last note affidavit was filed.
The problem, I think, is there's nothing in the record to indicate that the note was ever in possession of the bank between the time the complaint was filed and the time the summary judgment affidavit was filed. There's no indication of any change of condition.
But the testimony
in terms of the bank having the note.
Between the time the complaint was filed and the
You're
time
arguing
the lost...
that the lost note affidavit just reflects the inability of the bank to find the note at a moment in time. But that lost note affidavit is consistent with what's in the complaint that was filed 3 months earlier, and there's nothing happened in between of record that we know of.
I can understand where you're coming from. Again, I'd like to reiterate that the complaint did not just have a lost note count. It also stated that
we
they were
understand
the
that,
holder.
counsel, but what the complaint does has a burden of proof that goes along with your client. And we're not worried about whether the keys were there, but the question is the level of proof that was adduced before the trial court to establish by the greater weight of the evidence that you had the possession of the note at the time the lawsuit was filed. And it appears that the trial judge said, I am not persuaded on that point because I have this affidavit says we don't know anything. I have then a computer gentleman, a man who looks at the record, says, I can't stay for certainty. Well, the trial judge can rely on that evidence and find it inconclusive. My understanding is I don't get a chance to reweigh it. I am bound by the trial judge's legal ruling unless there's no competent evidence to support that. And I think what Judge Black and I are trying to drive at, it appears there's competent evidence to support the trial court's conclusion that the bank did not come forward with proof of evidence as to why was it found, where was it, to make sure that they established one of the elements of their cause of action.
I understand.
I understand you're not charged with trying the case. You're charged with arguing the record that you were given.
Yes, I just don't, it's my stance that the lost note affidavit should not be used to determine the possession of the note at the inception of
Well, can it be used to establish the credibility of the bank's witness?
Relates to a point in time. The court didn't comment on the credibility of the bank's witness. And in fact, I would like to point out with regard to the opposing counsel's, when he asked if the bank witness knew exactly when the note was scanned into the system. He says it was scanned in sometime in June 2006 when it was acquired in accordance with US Bank's policies and procedures. He stated that he couldn't bring a hyperlink to court, which is what would show when the note was scanned. And in addition, the bank presented other evidence to support these claims. As far as the acquisition screenshot not showing possession, again, the witness's testimony was that once that information was entered into the acquisition shot, it was locked and it could never be edited. And that acquisition screenshot, which is done during the boarding process, shows that that US Bank possessed the note when it was onboarded. So I do believe that the acquisition screenshot is important to plaintiff standing. In addition, again, the business records, the payment history show that US Bank has received payments on the loan from its inception. There's also in the file, at the same time when all of those affidavits were being filed, there was a notice of filing affidavit as to the date the note was acquired. That's the record, page 264. And it says that it's a sworn affidavit stating that the original note and mortgage were received by US Bank before the complaint was filed, and that they were received by US Bank in June 2016.
Thank
So
you,
there's
counsel. I
plenty
need
of
to advise
evidence
you
in the
that the
record.
time expired about a minute ago, but I wanted to let you have an opportunity to conclude your final thoughts. So I thank you very much.
Thank you.
The court thanks you both. You have a nice day, and please stay well and safe.
Thank you very much,
Okay.
Your Honors.
Okay.
Appreciate it. Have a good day.